As the legislature begins the redistricting process, they are ignoring a 2010 law, at least for now, that says prisoners should be counted at their last known address rather than where they are being held. That would shift many from the upstate Republican districts to downstate Democratic districts. The law was included in one of then-Governor David Paterson's budget extender bills, and because of the way it was passed, some Senate Republicans have filed a lawsuit challenging it, a move that has good government groups upset. My next guest was one of the sponsors of that bill. Assemblyman Hakeem Jeffries joins us from New York City to talk about prisoners in redistricting. Assemblyman, thanks for joining us.
Nick, good to be with you.
Great. So I just want to start a little bit with this issue of LAFTOR. That's the Commission of Lawmakers who are setting up the redistricting lines right now. If they draw the lines, the governor says he's going to veto it and put in his own independent panel through the court system, essentially. But they say so far they are not following the law. What does that do to this process, and what does this do to some of the districts in New York City?
Well, it's an unfortunate decision by LAFTOR. The legislation under discussion was a historic law that was passed last year. Only two other states, Maryland and Delaware, have changed the way that incarcerated individuals are counted for purposes of legislative redistricting, because they also have recognized that the prior system was unfair, unjust, and undemocratic. We passed the law legitimately in both the Senate and the Assembly. Governor Paterson signed it into law, and it should be enforced moving forward.
Right, but the issue that they're taking is with how it passed specifically is that it was included, it was a policy decision that was included in a spending bill, and the lawsuit is essentially over the governor's power to include it in a budget extender bill. Doesn't it give some pause as to whether this measure can hold up in the courts?
Well, not at all. There's been a long-standing debate stemming from the Silver v. Pataki decision that essentially gives the governor some extraordinary power as it relates to the types of matters that are included in budget bills. In this particular case, to the extent that there's any legitimate challenge to the governor's authority in this area, it occurs in the context of budget extenders, where essentially the governor presents the legislature with a take-it-or-leave-it choice. Either include and pass these provisions, which I'm jamming down the legislature's throat, or be faced with a government shutdown. In this particular case, there was a very different scenario. The agreement to change the way that incarcerated individuals are counted was a three-way negotiated agreement between the Assembly majority, the then Senate majority, and Governor Paterson. There was no compulsion involved whatsoever, and therefore the issues that are being raised by the current Senate majority really have no legal merit.
Isn't this almost a moot point, though, if in case the governor does eventually veto these lines, as he's pledged to do if they're drawn by lawmakers? Isn't it almost a moot point because eventually they'll just wind up drawing these lines based on that law if it does indeed hold up in court?
Well, it may turn out to be a moot point, and the governor, I think, has indicated that he does plan on vetoing any lines that derive from a partisan process, and I, of course, support the move toward an independent redistricting commission, which would do things in a different way. I believe there's significant support in the Assembly for that proposition. In fact, Speaker Silver is carrying the governor's bill. Again, there's obstruction and resistance in the Senate toward doing anything that would obviously impact adversely the Senate's ability to artificially maintain their majority, given the dramatic demographic changes that have taken place in New York State, which are unfavorable to the current majority in the Senate. And that's what this lawsuit is really all about. It's a naked attempt to instruct a law that was historic in nature, that rectified one of the most significant civil rights wrongs that had been taking place in the state of New York.
Sure. And
it was a perversion of our democracy, and hopefully we can get on with the charade. The courts will rule relatively soon, and incarcerated individuals will be counted as residents of their home communities.
And we should say also to the viewers that we would have Senate Republicans on to talk about this suit, but in fact, since many of them are plaintiffs in this suit themselves, including Senator Michael Nozzolio, Senator Tom Libous, Senator Betty Little. Republicans all are on the suit and say they can't talk about it since it's pending litigation. But I just want to back up to the court's ruling soon on this. Senator Nozzolio and Assemblyman Jack McEnany, who is your conference's leader on the LAFTOR Commission, have both said that they want the courts to rule quickly on this. They even sent a letter to the courts saying, you know, let's hurry up and deal with this. Do you think they're moving, the court that is, do you think they're moving fast enough in trying to litigate this?
Well, you know, I'm hopeful that we will see an expedited resolution. Obviously, we're under significant time constraints as it relates to our obligation to redraw the lines in advance of the 2012 election. The court does seem to have been moving with some degree of deliberate speed, and hopefully we'll see that speed increasing
Deliberate
in the next.
That sounds like they're moving too slow for you. Deliberate speed just sounds like they're
Absolutely. Well, they're absolutely moving too slowly, and I think that, you know, that language, of course, was famously written into the Brown v. Board of Education Supreme Court decision, which again was historic in nature, but as it related to its implementation, took a long time to rectify an injustice, which everyone recognized was the case. And many of us believe that exactly is the situation right now. There was an injustice, the legislature rectified it, we need to move forward. There is this judicial obstacle, but we cannot halt the entire legislative process simply because a lawsuit that I believe and many believe is baseless is serving as an impediment. And many of us in the Assembly, certainly the Black and Latino caucus, which strongly supported this change in law, of the view that we don't want to be co-conspirators to the obstruction of justice in this particular instance by ignoring a law that is on the books and is completely legitimate.
So if it's struck down, what happens? What do you do? What's plan B?
Well, if it's struck down, I'm certainly confident that there will be an immediate appeal, and this may be an issue that ultimately is resolved by the highest court in the state, the Court of Appeals. But I think that's just a hypothetical situation which I don't expect to occur. This is a sound law, both constitutionally, from the perspective of the manner in which it was done, as well as substantively in terms of rectifying a clear injustice.
Let's talk about the overall issue of independent redistricting. Both Senator Nozzolio and Assemblyman McEnany, well, actually Assemblyman McEnany disagreed, but Senator Nozzolio said that there's not enough time to actually set up this independent commission. Assemblyman McEnany said it would be dumb, essentially, a dumb approach of the governor to veto the lines without first judging the final product of the lines drawn by lawmakers. Do you think that there's enough time to still get an independent redistricting commission in place in time for early 2012?
Well, I absolutely believe that there's still enough time. In the 2002 redistricting cycle, I believe that the lines were not ultimately released until February of that year. And so we still have more than 6 months, and we should work as hard as we can to make sure that the process is as fair and as just and as equitable as it can be. We had a very successful legislative session under the leadership of Speaker Silver and Governor Andrew Cuomo. We want to build upon that momentum and continue to restore the confidence of the people in our ability in government to do the people's business. Perhaps the best way that we can do that moving forward is to make sure that elections are as fair and as equitable and as open as possible. And legislators should not essentially be given the ability to determine who they represent. The people should decide who represents them, and that is what an independent redistricting commission stands for, and we certainly have enough time to implement it.
After the first LAFTOR meeting in Albany, there was some talk of a possible compromise that the governor would develop some sort of commission that would maybe even give some lawmakers some power to draw lines, but ultimately it would be essentially an independent commission. There's still room for compromise here. Should your colleagues come back before the end of the year in a special session and take this measure up? Should you wait for the governor to call a special session? I mean, what's the game plan here going forward?
Well, I certainly think that we're not done as it relates to our Albany responsibilities. We're going to have to return at some point, whether that's in a few weeks or a few months, but certainly by the fall of this year, I would think, in order to address this redistricting question. And keep in mind, Nick, the governor does have extraordinary power here because given his ability to veto any legislative redistricting product that we present to him, the votes don't exist to override any veto that the governor may engineer. And as a result, we need his cooperation in order to move forward with the redrawing of these lines. And given his insistence, at least to date, that there's got to be more of an independent, less partisan process in place, we're going to have to find a way for there to be common ground as it relates to what we do differently than what has been done in the past.
And Assemblyman, we're almost out of time, but I just want to ask you one last question before we go. How is your House campaign going so far?
Well, you know, it's not a campaign yet. It's just a congressional exploratory committee.
That's right. Sorry, exploratory committee. You're right.
And we've been engaging in conversations with community and institutional stakeholders all across the community. Those conversations have been going well. But I don't expect to come to any resolution until the end of the year at the earliest. But certainly now that the legislative session is over, I have had the opportunity to begin to have more serious conversations about the possibility of seeking a seat in the United States Congress next year.
Okay, we'll have to leave it there. Assemblyman Hakeem Jeffries, thanks for joining us on the show.
Thanks for having me.